So rearrange the schedule a little bit so we can start our conversation on H10 now. And then at 11, or 11-ish, we're gonna go to H222, and then we're gonna come back to H10 after the floor, hopefully having saved a little bit of time by starting it now. So, David, if you could take us through H10, and so folks know, we haven't really talked about veggie very much in committee yet this year. Emily Byrne and Tom Cavett are gonna come in later to sort of talk through some of the big picture mechanism of it all. But David has spent countless hours of his life on this topic and can also very much help us through this. Floor is yours, David.
Thank you. Good morning, David Hall, Legislative Council. Would you like me to share the bill
I think that would be great. Thank you.
on the screen? Great. So this time we are talking about veggie, which is the Vermont Employment Growth Incentive Program. We are also talking about Vermont Economic Progress Council, which is the state entity that sort of oversees, approves applications for, manages two processes, the Vermont Economic Growth Incentive Program, veggie, and then also the TIF program. And those are built in similar ways, intentionally so. But this bill does not deal with TIFs in any way. This is just veggie.
What? I don't want to correct you, but I would say that anything having to do with the council itself would tips a little bit. Maybe that's a little peripheral of me.
It doesn't change any of the programmatic issues relating to TIFs, nor does it have any specific change to the council or its operations with respect to TIFs.
Thanks.
It does change some pieces about the council, and then some specific aspects of veggie with respect to the council. So there's interplay there for sure. And then there are a series of changes, discrete changes to veggie. So it can be hard to just sort of jump into the middle of veggie and say, we're going to tweak this little piece like that without having a broader context of how things work. So I'm going to move forward with the language of the bill. But if you have specific or even general questions about veggie, its operation, function, I'm happy to try to help you orient yourself to those things too. So a few years back, we rewrote and republished an update to the VEPC and veggie pieces of law in Title 32, Chapter 105. And Subchapter 1 deals with the council. Subchapter 2 deals with veggie. So the first instance you see here in your bill, this is a change to the council itself. So you'll see, as I said, governs veggie, governs VEPC, governs TIF. Membership is 11 voting members, 9 of those by the governor. There's one House member, there's one Senate member. There are non-voting regional members that appear at meetings when the application comes from their region. These are the RDC, RPC non-voting members who attend. So you'll see the first change here on page 2, subdivision 3. The council shall provide not less than 30 days notice of a vacancy to the relevant appointing authority, which shall appoint a replacement not later than 30 days after receiving notice. So I'll pause here and say, there are a lot of functions of statutes, right? And one of those is a signaling function. And I would say, The real value here of subdivision 3 is to give a specific and explicit statutory message that we don't want these positions to be sitting vacant for months at a time. So
Are you aware of that being an ongoing problem?
I understand from public testimony that sometimes has been a problem. I say it this way and I phrase it and couch it as a signaling function because, I mean, in truth, there is no mechanism here to to address what happens if something goes wrong. I mean, what if they don't do this? What are you, somebody going to sue the governor with a writ of mandamus action to say your statutory duty is to appoint these people, so do it? I mean, that's really sort of the outside realm of what you could possibly even hope to accomplish. And even then a court might say, you know, this is an internecine, interbranch sort of conflict that is a political question that we won't get involved with. So I'm not going to sit here and tell you, you know, bad things are really going to happen if the governor, for instance, or the speaker doesn't appoint the person within a 30-day vacancy. If that happens, there's not much recourse, but the function here is to put a note out into the world, signal to the appropriate people, including the council and the appointing authorities, hey, we really don't want these positions to lapse for 6 months at a time.
Thank you. Representative Bodie?
Thank you. So when you say the council provides not less than 30 days notice of a vacancy,
Yep.
that means within 30 days of knowing you have a vacancy, you have to provide notice to the relevant appointing authority.
Right.
Okay.
So they're either going to, the VEPC is going to say to the governor, to the speaker, to the Senate Committee on Committees, we've just learned that there's a vacancy and we're giving you this letter and saying pursuant to this statute, please appoint a replacement within the next 30 days is how I envision it would play out.
I have a couple of follow-ups. If there aren't enough people appointed, does that affect the ability of this council to have a quorum so that they can conduct business?
Yes.
Would another option be to add that the quorum could go down in number if if there isn't a reappointment, then at least your quorum would be a percentage of the people who are actually holding seats on the council so that you could still do business?
Yeah, I mean, you could do that. I don't think it's ever reached the level where it can't function because there aren't enough members to do business. I think rather there hasn't been the full scope of representation and discussion that they would like for applications.
I know that the Commerce Committee and in previous conversations about this, it was very important to make sure that there was a diversity of opinions sitting on the council. And just in terms of sort of, there's the timeline crunch that we're on because of crossover and sort of where we are and needing to do things. There's also the fact that this bill is something that we really have like full cross jurisdiction with from commerce. It's not just a commerce issue because essentially everything that VEPC does deeply affects the revenue of the state because it's all tax programs essentially. So while we certainly don't have time to be nitpicking language, this is something where we really do want to have a full understanding of what's happening here. And we can hear from Tom this afternoon about that in greater depth.
Okay, so I would just say if we had a lot of time, I would love testimony about whether we should do something about the quorum, but I'll go with that you haven't heard that there's a problem and that we haven't time.
I think the bigger problem is the diversity of voices on the council. Back to you, David.
Sure. All right. I just want to make sure that what I'm saying on your record is clear is that I have not heard public testimony that obtaining a quorum has been an issue for this council. And that's the extent of my perspective.
Thank you very much.
Sure. So on page 3, we're talking about the operation of the council. And there are a couple new pieces here. So we have subdivision 4. The council shall adopt and make publicly available a policy governing conflicts of interest that meets or exceeds the requirements of the state code of ethics. It shall include clear standards for when a member of the council may participate or must be recused when an actual perceived conflict of interest exists. And B, a provision that requires a witness who is an officer of the state or its political subdivision or instrumentality to disclose the conflicts of interest related to an application. So I'll just flag that, members of the council sort of already covered by the ethics policy that governs state employees, boards, commissions. I have heard, testimony that is applicable to them and they feel sufficient. I don't see any, obvious legal harm in saying, have your own policy, adopt it, make it public. So whether this is necessary or not, policy choice for you. I know that part of the, I think,
I'm gonna maybe
yeah,
for a moment. So the underlying bill that was amended by Commerce was co-sponsored by Chair Marcotte and I. I feel like that might be worth saying out loud for transparency's sake. And each provision of it was really designed to answer a previous policy concern that had come up on this issue. It wasn't sort of out of a vacuum. It was us working together on like policy concerns that had come before both of our committees over and over and over again, including come to Joint Fiscal Committee a number of times. And so the underlying bill is an attempt to answer all of those concerns. The bill has been pared back significantly to answer a few of those concerns in the short term and then ask a much more comprehensive task force to look further into those larger concerns. And I think Tom Cavett can talk us a little bit about some of the sort of fiscally related concerns this afternoon. But that's sort of the context for the bill as David is trying to parse it with us now. Is that helpful?
that's great.
Okay. Back to you.
Unless there's questions on 4, I'm going to jump to 5. So the council shall not enter into executive session to discuss applications or other matters pertaining to the veggie program unless the executive branch state economist is present and has been provided all relevant materials concerning the session.
This is Carr, not Cavett.
Well, right now, Jeff Carr, yes, it doesn't always need to be him, not Cavett. The on the ground distinction here is executive branch state economist in that capacity versus maybe an in-house employee or other person who is not named as such. So we want to make sure that.
Yeah.
Remind me who the current executive branch economist is?
I believe it's still Jeff Carr.
Okay, that makes sense. I lost track. Thank you.
No worries. Okay. Are we ready to move on to cost benefit model? Okay.
Every minute.
So this is the next piece under the council's jurisdiction. You'll see in A, the existing law, that the council shall adopt and maintain a cost benefit model for assessing and measuring the projected net fiscal cost and benefit to the state of proposed economic development activities. The council shall not modify the cost benefit model without the prior approval of JFC. Those are existing law. So the new pieces, C1 and 2 here. The council shall contract with the executive branch state economist to perform the cost benefit analysis using the cost benefit model when considering application under veggie. The executive branch state economist shall consult with the joint fiscal office or its agent concerning the performance of the cost benefit analysis and operation of the model for each application in which the value of potential incentives an applicant may earn equal or exceeds $1 million. So if the model is the little black box into which we put all the inputs and it spits out net fiscal benefit and what the incentives may be, this relates to who runs it and who assesses it and who conducts the analysis. At what point do we have the legislative state economist, in this case, who works as JFO's agent, join the conversation? And Commerce chose to peg that at an application with a potential impact of $1 million or more.
Yeah.
Is the trigger dollar value something that's been around? Where does it come from?
This is brand new.
Does it catch, if you will, the kind of situations that the auditor amongst others have said are not really up to snuff? Is that a good dollar value for a trigger? I don't know. I don't have a context to make that judgment.
I think we could take a look at the annual report, which does say the size of the awards. I think most of them are under $1 million.
Yeah, I mean, just at the most general level, I'll say that's a largish package of incentives. If if the total annually authorized amount of the program is initial approvals of 15 million, final approvals of 10 million, and that can't be raised without approval of joint fiscal committee, this would be, obviously $1 million out of the 10 million is a lot. So it's a high number. Is it satisfy the auditor or those other questions I can't?
Okay, no, I understand. And that was my intuition too. It seemed like a high number to trigger, but I'm new to this area.
So the issue.
You lost your screen share.
Oh, goodness. The issue that's happening here, as far as who runs the model and whether the JFO or its agent are consulted is really one of administrative cost. I mean, obviously, it costs more to pay an independent economist to do this work than it would an in-house employee who's already on the job. So it's a balancing between those competing factors, I'd say. And obviously, the other element is oversight, which is, and maybe you can't quantify, but it's also one of the things going on here. Any questions on subsection C? Okay.
I would have gone lower, but hey, only one person. I'm an old-time boy, and those figures scare me.
Let's go through the whole bill and then hear from Emily and Tom, and then sort of, discuss our discussions to make sure we all understand what's here.
So, when we move to section 3 here, we're sort of skipping over the program and the way it functions and operates. And, various iterations of this and 100 other bills have made tweaks here and there. But section 3 jumps straight to the reporting and addresses the type of information that comes out of the program. So you'll see under current law, it's an annual September 1st report. It's VEPSI and the Department of Taxes submit a joint report on incentives to committees of jurisdiction. And the reason that we haven't talked about it, but the reason that it's both is because the program is essentially bifurcated between application right up to earning, and then from earning through award. And the former is VEPSI. So it does all the intake, processing, approvals, setting up what your targets are going to be, blah, blah, blah. It's actually the Department of Taxes that does the analysis of whether you have met your performance requirements, you have earned your incentives, and you receive the payout. So both of those parties are at the table and on the hook for reporting this information to the legislature. So in B, the council and department shall include in their joint report the total amount of incentives authorized and then the amount per business. So that's new. Other new things, lines 12 through 7 through, go ahead.
I didn't, go ahead, finish your sentence, I was just
No.
putting myself in line here.
Okay, well, is it about B1?
Well, it's the $25,000 increments,
We're not, okay.
when appropriate, I guess, when I'm talking. Is that, are there multiple purposes for the $25,000 increments? I mean, it seems to me if I'm the business, it could protect who I'm hiring from, or, some proprietary information up in that, or is there other reasons too?
It's both for the business and for potentially the individual.
Okay,
I mean, an articulated concern is that if there's a small number of new employees added through the program, even though the information may be aggregated, reported in bands, if it's not, then maybe we can figure out what one person's salary is.
and I'm not fussy about it, I was
Sure.
just curious.
Yeah, that's really the purpose of having
Okay.
groups and bands by salary rather than individual salaries. So 12 through 18, the other new information that would come along, the aggregate number of new qualifying jobs anticipated to be created. Vermont gross wages and salaries for new qualifying jobs sorted by groups in $25,000 increments. Aggregate amount of new full-time payroll anticipated to be created, and the next code. So breaking those down, qualifying jobs is a defined term for purposes of the statute. There are a lot of requirements that you have to meet to be a qualifying job, and it's based on something we call the wage threshold. It's based on whether you offer 3 or more of a certain panel of benefits. It includes the quote unquote look back provision, which says you can't just add back jobs that you had previously axed and now you're rehiring somebody and getting credit for that. That doesn't count. That's not a new qualifying job. So qualifying jobs are a defined term. Vermont grows wages and salaries a defined term. I mean, there was a lot of discussion about what about tips or commission or anything else. We're just saying this is your W-2 Vermont income right here.
Is there a reason why you left the and in line 17?
I didn't hear what you said.
Yep. So the way that subdivision 2 is constructed, that's one big list that, so you have to link G to H, but then H links, the and in H links 2 to 3. You know what I mean?
Oh, I see, okay.
So that NAICS code, that's our industry code that will tell us, what industry this new activity is occurring in. Following aggregate information for claims processed. So we've got a number of claims, number of qualifying jobs for each claim, amount of new payroll and capital investment for each approved claim. So it's a little bit more granular data on a business and claims basis. That said, Commerce also added C2, notwithstanding provision in the section of the contrary, when reporting data and information pursuant to this section, the council and department shall take steps necessary to avoid disclosing information that would enable the identification of an individual employee or the employee's compensation.
So if only 2 jobs are created by one employer, you wouldn't be
Right.
reporting that wage data because that would violate their privacy a little bit.
Right. That is it for the reporting piece, unless you have questions. So the next piece deals with confidentiality of proprietary business information. And fair to say this has been a source of material for controversy over the years. This section is actually one of the few that was not really repackaged and rewritten in the 32 VSA Chapter 105 rewrite. But there's not a lot of change right now. The change in subsection B is intended to just make explicit what we thought maybe was already implicit, which is information and materials submitted by a business concerning its application income taxes, and other confidential financial information. So those are not subject to the public records law under 1 VSA Chapter 5. But all that stuff is available to the Joint Fiscal Office or its agent upon, right now in current law, upon authorization of the Joint Fiscal Committee or a standing committee of the General Assembly. That information is also available to the auditor right now. So the additional line 3, because there are 2 legislative members on the council, this specifies that the approval for JFO or its agent to receive all of this information could be made by a legislative member of the council.
So-
At first glance, that seems pretty,
Pretty well.
I don't know, just goes almost too far because the joint fiscal committee or a standing committee you'd have to have.
I think the challenge is that
Majority.
historically, the Joint Fiscal Committee or the Standing Committee was not aware of times where they might want to be making that request. And so it became a little bit circular. And so this just sort of creates a more direct pathway to have those conversations.
Couldn't the legislative member of the council ask the standing committee or the joint fiscal committee?
To then ask the Joint Fiscal Office?
Yeah,
Sure, it just gets really circular and it's just making information available to Joint Fiscal Office. It's not making it publicly available.
I want to also just, state for your record, because we stated it, and when I say we, I've met with my colleagues in L's Legislative Council and in Joint Fiscal Office. And so the question came up in Commerce and it may come up here, why can't the Joint Fiscal Office or a standing committee just sort of give a blanket authorization that says anytime an application and materials come through, automatically give it to Joint Fiscal? I don't see any reason why that can't happen because the way that this section is written, it is not time limited. It's not data limited. And it seems like JFC could issue sort of a standing request. A future JFC could certainly rescind that request. But I think this is written broadly enough that, a standing committee or a joint fiscal committee could say, going forward, we just want you to automatically share this with joint fiscal. So that is an operational change, not a legislative change. The legislative change obviously is just intended to shorten the process and to avoid the situation where when the legislature is not around, when joint fiscal committee is not scheduled to meet, we have a more expedited process for instance, the legislative economist to be able to receive materials involved in an application. Any questions on 3341? Okay. So section 5 is extending the so-called sunset of veggie. It is set to expire next January, and this would push that out for 2 years. The program does operate on the calendar year, so pegging it to January it avoids a lot of problems of trying to peg it to July 1st. Questions on that? All right, section 6, I don't know how much time you want to spend on this. This is a study on economic development incentives.
I want to spend 11 minutes on this bill
All right,
before we pick it up again.
11 additional minutes?
11 more minutes.
All right, well, that's
Yes.
probably more than we need.
Yeah, so please tell us about this.
All right. Well, so this section began life as a study specific to veggie, actually. Should it be changed? Is it appropriate? How does it work? How can we improve it, et cetera? But after some significant discussion in House Commerce, its focus was much more broadly expanded. So it creates a task force on economic development incentives as 5 members, a member of House Commerce, and then an at-large member appointed by the Speaker, a member of Senate Economic Development, and then an at-large member appointed by the Senate Committee on Committees, and then finally, one at-large member appointed jointly by Speaker and Senate. Obviously, this is skewed toward the legislature, and it does name those two committees of jurisdiction, but not this committee or finance. So
Much noticed, thank you.
not I just write the words here. But that's the construct for the 5-person task force. So this task force would conduct hearings, receive testimony, review, and consider purpose and performance of current state-funded economic development incentive programs, and also models and features of economic development incentive programs from other jurisdictions, including structure management oversight features of the program, articulated purpose, goals, and benefits of the program, basis of measuring success, and the mechanism for providing the economic incentive, whether that's through a loan, a grant, equity investment, some other approach.
The phrase state-funded is a breathtaking net that reaches to the regional DCs and.
I think it's a good point. Frankly.
Maybe, it should be. I'm just pointing out that
Sure.
following the state money is an interesting way to rope in, if you will, a study.
Yeah, to some extent, I think this task force will have to draw its own boundaries. It does, is couched as economic development incentive programs. So, nominally we're thinking about things like veggie and other business, but, obviously there's a good faith argument that lots of things are economic development, childcare, education, infrastructure, broadband. So I don't think that's the direction this task force will go. It certainly doesn't have time to do that the way it's written, but to some extent it's going to have to.
But RDCs likely.
Well, they are state funded.
Yep.
In the work that they do. Are they an incentive program? Not everything, but for instance, the bill we just looked at had that technical business exchange. That would be an example of a state funded, though RDC administered economic development incentive program, I think. Or they could say it's not. This is just technical assistance. So again, they may have to choose. You'll see in subsection C here, the task force will have the whole suite of administrative, fiscal, and legal support. It does authorize, you'll see in 2, JFO to issue an RFP for agreements for consulting services to the extent that's necessary. The report is due January 15th. With findings and recommendations for legal action, legislative action, including whether and how any proposed program addition, revision, or other legislative action would integrate with and further advance the current workforce development, economic development systems in the state, and advance the 4 principles of economic development articulated in 10 VSA 3. You may not know that we have those, but we do. You may remember a process called CFED, Commission on the Future of Economic Development, which transpired maybe 10 years ago, the product of which was a very extensive report and recommendations on economic development, and included the adoption of the 4 principles of economic development currently in statute.
I don't think I've ever read that report, and I would love if you could send it to me whenever you have a minute.
I'll try to dig it up. The meetings should begin on or before September 1st. They'll select their own chair. The majority is a quorum. It disappears in January. You are entitled to compensation. And there is a $250,000 appropriation from the general fund for compensation, reimbursement of expenses, and for consulting services approved by the task force.
Thank you.
All right.
So we're gonna pick up this conversation again after the floor. And look forward to everyone returning here after the floor, yes.
David, what was the vote out of Commerce Committee?
I have no idea.
11-0-0.
Thanks, Rachel.
Gotcha?
Yeah.
She's so good.
Yes.
All right, any questions about H10?
If the floor goes past some hour, check in. I'll think on what that hour is. I'm gonna think on what that hour is. Speaking of the floor, before we switch gears to 222, and thank you so much, David.
Yes, ma'am.
We have 3 bills on the floor today. We have H55 and H471 for third reading. And then we have H178 with Rep. Taylor for second reading. And we have a whole slew of stuff on notice or about to go on notice.
Is there H 201, 102?
But no, that might be an appropriations.
You got a whole pile of them down there.
We do have a pile of bills and appropriations that they're working through.
Okay.
So how late do you think the floor will go?
I am not qualified to answer that question. Representative Canfield, how long do you think the floor will go?
I'm just looking. It's gonna be.
No.
Betsy Ann imagines 4 o'clock and she is actually almost over, right? But I don't want to hold her by that.
Jinx. Okay, and then back up here, so we're out of here by 5.
Mhm. Yes.
I only asked, my husband's coming down